when you click on record, you have two options: record to this computer, record to the cloud.
Muy bien, muy buenos días, buenas tardes.
Hello, good morning, good afternoon, or good evening to all of you, depending on where you are located. I hope you can hear me fine. And before I start, I'd like to inform all participants that we have interpretation services for this training session, and we will be providing Spanish, English, French, and Russian interpretation. I would be very grateful to the panelists if they can speak slowly so that the interpreters can do their job. If you need interpretation, please click on the icon similar to the world icon at the bottom of the screen and choose your language. My name is Hernan Valles. I am Chief of the Indigenous Peoples and Minorities section of the Office of the UN High Commissioner for Human Rights, based in Geneva, in Switzerland. And I would like to warmly welcome you to the first training for Indigenous peoples organized by the UN Voluntary Fund for Indigenous Peoples. it has also the support with the High Commissioner Office. As I said already, this is the first in a series of trainings that we will be organizing during 2023 on the human rights mechanisms of the UN system and its work on indigenous peoples. There are also other issues of particular interest to indigenous peoples. Therefore, we would like to invite you to join us not only today, but also in the other trainings we will be organizing. One of the main goals is to improve the capacities of the fund beneficiaries so that they have the necessary knowledge before they participate in the different UN mechanisms. But this training is actually open to everybody. We hope that many people can take advantage of it, especially if they are part of indigenous peoples. Today's session has been organized in collaboration with the Urgent Action and Petitions section of my office, the Office of the United Nations High Commissioner for Human Rights, also Indigenous Peoples' Rights International, IPRI, and International Service for Human Rights and Cultural Survival. We thank them for their valuable contribution. Today's agenda includes a brief introduction of the UN Voluntary Fund for Indigenous Peoples, and it will be presented by Morse Flores. He's the secretary of the fund. And we will also have a general presentation on UN treaty bodies by our colleague, Ms. Karine Rinaldi of the Petitions and Urgent Action section. After her presentation, we will take a 20-minute break. After the break, Fergus McKay of Indigenous Peoples' Rights International, or IPRI, will speak to us about strategic decisions of the treaty mechanisms on indigenous peoples. Finally, Vincent Ploton of the International Service for Human Rights will share with us his experience working with the Committee on the Elimination of Racial Discrimination on a case from French Guiana related to indigenous peoples. At the end, we will have a brief Q&A session. If you have any questions or any comments, please post them in that section in the Zoom, post them in the chat as well, and we will read them out. And without further ado, I'd like to introduce you to my colleague, Morse Flores, Secretary of the Voluntary Fund. He is also the coordinator of Indigenous and Minorities Fellowship Programs. And after Morse's presentation, my colleague, Arturo Requesens, will continue moderating the event. I hope you enjoy today's training, you enjoy the session, and you take many lessons with you. Thank you.
Good afternoon, good morning, good evening, colleagues. I will be giving you a very short snapshot, an overview of what is the UN Voluntary Fund for Indigenous Peoples, basically outlining the key mandates of the fund and introduce you a bit of the different activities of the fund. And one of them is capacity building. That's where we are now. And then I think the most important for you is to understand, the grand cycle of the fund, because this is where you will be coming in as one of our key actors. And then I would end up by providing you some practical tips on how to ensure that your interest in participating in some of these most important and relevant mechanisms specific to indigenous peoples is accessible to you. So what I'm going to do is I'm going to share to you our website on the fund, so then you get familiar immediately on the website. So everything that you need to learn about the UN Voluntary Fund is a part of our office website, the Office of the High Commissioner for Human Rights. So you could see here very quickly in terms of the purpose of the fund. It's basically one very important is to ensure that there is a sustainable presence of indigenous peoples in the most important UN mechanisms and processes that we have. And when we talk about these important processes and mechanisms, that's where we have the mandate of the fund. So in terms of the mandate of the fund, so the fund will provide you financial support to participate in the several UN meetings or processes. So the most upcoming now, and then I will explain to you later on the calendar of the fund, is the Permanent Forum on Indigenous Issues that usually takes place for 2 weeks in New York every April or May. So take note, that's one of them. The Permanent Forum on Indigenous Issues in April or May. Following that, then we have the UN Expert Mechanism on the Rights of Indigenous Peoples, EMRIP in short. It happens in Geneva, like the Permanent Forum. This is also an annual meeting. It happens either in June or July in Geneva for 1 week, okay? Permanent Forum, the Expert Mechanism. And then the next one, taking place again in Geneva, is the Human Rights Council. The Human Rights Council meets 3 times a year, one in March, one in June. So next June, there is a Human Rights Council, and the other one is September. The most important session for the Human Rights Council for Indigenous people is the one in September, because this is the session wherein the expert mechanism on the rights of Indigenous peoples and the special rapporteur provides their report to the Human Rights Council, right? Now, subsidiary to the work of the Human Rights Council is the UPR. It's the Universal Periodic Review Process, where in every single country in the world's human rights record is reviewed by the UN. The UPR, like the Human Rights Council, they also have 3 sessions. They are more or less attached to each other. And it happens again in Geneva. Now, these are the bodies of the UN that is part of what we call the charter-based bodies. Now, let's complete the charter base, okay? Now, there's this very new mechanism where the fund is providing support. It's the UN Forum on Business and Human Rights. We started last year because of the expansion of the mandate of the fund in 2019. In addition to that, another expansion of the mandate of the fund is the support of the fund to Indigenous participation at the meetings of COP, or should we say the climate change processes. And that happens in different parts of the world. So the last one was in Sharm el-Sheikh, Egypt. So remember, those are the charter-based bodies of the UN. You are able to participate on those bodies for the fact that your country is a member of the UN, all right? Now, the other side of the bodies are what you call the treaty-based bodies. We have 10 core human rights treaty bodies, and we are actually, this session is about this mechanism. And I'm not going to give you details on that because that's the assignment of my colleagues now. But when you talk about, for example, if you have heard about CEDAW, CRC, the Human Rights Committee, CERD, these are the treaty-based bodies. 10 of them, you can have access from the fund to participate in those sessions of these treaty bodies. Now, when it comes to criteria of selection, I'll just show it to you where to go, depending on which UN body that you are interested to participate. You see here, for example, you have criteria for participating in EMRIP. There's a criteria for the Human Rights Council. There are different criteria because each of the body of the UN, depending on the status of your organization or your community, they have different criteria. I'll give you one example. For the expert mechanism on the rights of Indigenous peoples, you don't have to have a certain accreditation that in the other mechanism requires. On the other hand, if you want to participate in the Human Rights Council, including its subsidiary body, which is the UPR that I just mentioned to you, you need to have a consultative status with the ECOSOC. ECOSOC is one of the principal organs of the UN. It's called the Economic and Social Council of the UN. If you haven't heard about it before, keep that, take note of that. And then if you have questions, I will put my contact detail later on, and you will have access to that. So if you become a beneficiary of the fund, what do you have? What do you get? You are provided with a stipend for the duration of your stay in that specific meeting. If it's an EMRIP, it's for 1 week, Permanent Forum for 2 weeks. You get your plane ticket as well. So basically, you are covered for the whole duration of your stay. One thing that the fund doesn't provide, though, is your travel insurance. This is under the responsibility of you or your organization, and the visa. Finally, tips for you when you are applying for the fund. I'll quickly show you our grant cycle. Okay, the fund, we call it a revolving cycle. We have basically 4 cycles. We follow first, second, third, fourth quarterly. Okay, so the first quarter is usually from March and from January to March, April to June, July to September, October to December. Take note, normally the call for applications, it's being done or it's shared with everybody in our website 3 months in advance. So how it works, all the meetings that is taking place from January to March will be advertised or shared 3 months in advance. And of course, the reason for this is that to ensure that when you are selected, you have time to apply for your visa, and we have time to administratively ensure that you'll get your plane ticket and all the administrative work that we need to do beforehand. All right. So please, I would advise you to apply on time or even in advance. All right. So these are the listing of the different meetings that the UN, the fund provides support with you. Just one last, of course, we had a board of trustees that actually the one who do the selection. Where is that? Here. So as I was telling you, I was explaining this to you. So for example, here, all the sessions that is taking place April, the Permanent Forum, the Human Rights Council in February and March, the people have been selected as early as in December. So it's always 1 month in advance. I'll stop here because this is just, an introductory to the fund. But what I would like you to do is to visit our website very soon and see what are the ongoing call for application. If you do participate in the fund, take note that you are required to submit an evaluation form towards the end of your participation. And the final evaluation is being asked through the organization that is recommending you or that you have represented to see what's the impact of your participation into those important UN meetings. I'll stop here. If you have any question, please don't hesitate. Hopefully I can come back to you afterwards. So thank you so much once again, and all the best with the training. Over to you, Arturo.
Thank you so much, Morse. Muchísimas gracias, Morse.
Thank you so much, Morse. My name is Arturo Requesén. I'm an officer of human rights at the UN office here in Geneva. And it is a pleasure to moderate this session. And without further ado, I would like to welcome Karine Rinal. Karine Rinaldi will share with us some comments about the processes and the mechanisms on UN body treaties. Karine Rinaldi is a law graduate. She also has a master's program in international law and a PhD in human rights. She has extensive professional experience with civil society organizations, in particular, defending rights of indigenous peoples of Costa Rica, Panama, French Guiana, and Congo, as well as with international cooperation. Since 2018, she is Human Rights Officer for the Office of the UN High Commissioner for Human Rights in Geneva in the Petitions and Urgent Action section, and she assists the UN committees in their quasi-judicial function. For us, it is a joy to welcome her. Please, over to you, Karine. Thank you. Thank you so much, Arturo. Well, good morning, good evening, good night, depending on where you are. Thank you to the UN Voluntary Fund for their invitation and for allowing me to talk to all of you about the UN body treaties. I'm going to try and share my screen now. Hopefully you can all see it. Could you please confirm whether you can see the screen in the chat? So we have about an hour, and I want to explain to you what are UN body treaties, what are their main functions. But I want to focus on two of those processes. These are two processes that the indigenous peoples can use in order to interact, in order to preserve their rights. And I will actually describe two very concrete cases that we have, where we have achieved several rights. So first of all, what are UN treaties? Well, they are committees that have been created by virtue of the treaties. What, as you know, treaties are negotiated texts that have been adopted by the states within the UN General Assembly. And these committees are made up of different experts, and the number of experts varies depending on the UN treaty. Some of them have 10 people, like CAT, the Committee Against Torture, and some have 18 experts, like the Committee of Human Rights. And these committees are created in order to supervise the compliance with the treaties by state members. When countries ratify the treaties, somehow they are making the promise to respect them. There are 9 international treaties on the protection of human rights, and each of these international treaties has created its own committee to ensure the follow-up of the compliance of that treaty. And here you are going to see in chronological order how it happened. In 1965, it was adopted the first international convention on the elimination of all forms of racial discrimination. Now, this convention was implemented in 1969, and that is when the committee started to work. In 1966, there was an international agreement on political and civil rights, and it was implemented in 1976, and that's the same year when the Committee on Human Rights started to work. And then in the same year, 1966, there was also an international agreement on cultural, social, and economic rights, and it was implemented in 1976 with its corresponding committee. In 1979, member states adopted the Convention on the Elimination of All Forms of Discrimination Against Women, and it was implemented in 1981 with its corresponding committee. In 1984, all member states adopted the Convention Against Torture or other degrading, inhuman, or cruel treatment, and it started to be implemented in 1987 with its corresponding Committee Against Torture. Later on, in 1989, we had the Convention on the Rights of the Child, but this one was implemented almost right away, only a year later, with its corresponding committee. In 1990, state members adopted the International Convention on the Protection of all rights of migratory workers and their families. It was implemented 13 years later in 2003, and it was in 2003 when the corresponding committee started its work. We have the last two. One is the Convention on the Rights of Persons with a Disability. This was a text that was introduced in 2008, and it was implemented in 2008. with its corresponding committee. And finally, we have in 2006, the International Convention for the Protection of All People Against Forced Disappearances, and it was implemented in 2010. As you can see, there are different treaties and different committees that are tackling specific rights and others that are targeting collective rights. There are CEDCAT and CID those are dealing with cases of torture, disappearances, and then there are treaties tackling specific groups, for example, and those committees working to protect children, to protect women or migratory workers. So, after describing briefly all the committees, let's have a look at its main functions. First of all, committees must monitor the enforcement of legal obligations that have been adopted by the member states when they ratify the treaties. And there are different ways of monitoring this. One way is final observations. Final observations on the ways that the state members are actually implementing those treaties. There are also different analysis of individual claims or complaints rather, and there are also exams of complaints between state members. There are only 5 committees of all of the 10 that we saw who have the ability to actually undergo one of these exams of complaints. I'm talking about CESC, CAT, CIDO, CLC, CPD. And you may know that in September 2013, CIDO carried out a complaint in Canada about the discrimination against women, and this committee concluded that there was an ongoing discrimination, and that was one of the reasons for the high number of disappeared and murdered women in Canada. If you want to have a look at it, this is the work of this committee, this CEDAW, and you can click on it. Now, this monitoring process is happening through the Committee on Forced Disappearances by visiting the country. If the country reveals or discloses some information about serious situations, then there is a group of the Committee Against Torture that is actually visiting the country. And this happened in Mexico in November of 2021. The committee met with different indigenous peoples and they issued a report. The report stated that these violations are happening within territorial conflicts, and it is related to mining projects or mega projects. It is also related to land grabbing on behalf of organized crime. I think the committee is also planning a country visit to Honduras. And apart all of these, committees have also a second function. They have to interpret the content of the treaties. They adopt general comments. Actually, the terminology differs a little bit from one treaty to another.
Disposiciones de sus tratados, de los artículos de los tratados. Y eso sirve no solamente para asistir a los estados en la implementación de las obligaciones derivadas del tratado, sino también, sobre todo, para desarrollar el contenido del derecho. Por ejemplo, el comentario general del Comité de Derechos Humanos sobre el derecho a la vida desarrolló el entendimiento del derecho a la vida, no solamente como la prohibición de quitarle la vida a una persona, sino también, por ejemplo, todo lo que tiene que ver con el derecho a la vida digna. ¿Y ustedes cómo pueden participar en eso? En la redacción, por ejemplo, en la adopción de esos comentarios generales. Las organizaciones de la sociedad civil, por ejemplo, u otros actores pueden enviar comentarios, digamos.
Civil society can also send comments to the drafts of general recommendations. And recently, there was CEDAW drafted General Recommendations 39 on the life of Indigenous women, and there was a wide consultation regional process with Indigenous women, and they got insights and inputs from different Indigenous organizations. And last but not least, on top of this monitoring function of the compliance with treaties and the interpretation function of the contents of the rights, some of the committees do have the function to prevent violations of human rights. Not all committees do have such a function. It's only the CERD, the racial discrimination, and the CED, the disappearance, and the CED does have an urgent action proceedings and early alert, which aims at preventing the fact that existing situations become conflicts, and also the measures for urgent action aim at responding for problems requiring action immediately to prevent escalation of the process, like sending letters or public recommendations to states or to recommendations to the General Security Council in order to prevent these type of violations when they can become genocide or conflicts. And it is interesting to say that in most cases, this is involving Indigenous peoples. I've also included a list of the measures and provisions adopted by committees, so you can see how these letters are structured and then understand how to present the situation to the committee. Also, there's a link to the guidelines on the procedures for early alert and urgent action. I'm saying no more about this procedure because I know other panelists speaking today had used the procedure and the process and will tell you all about their experiences. The other committee in having this prevention action to prevent a violation of human rights is the CED committee.
Mediante su procedimiento de
And in particular, there's a process for urgent action, calling state to immediately take action to find or to locate or to protect a person that is being gone missing or disappeared. Basically, this is a procedures that are specific to find people who are gone missing or disappeared, and this is also used for Indigenous peoples. I mean, we have urgent actions registered in Mexico against Mexico with regard to Tzeltal Indigenous people that have gone disappeared, or other paramilitary action. Then we have the same thing in Honduras, against Honduras, for the disappearance of leaders, Garifuna leaders from Triunfo de la Cruz, disappeared through actions by police agents in reprimanding their defense of their own territory. And also we have actions, urgent actions, against Burkina Faso. Just to give you another example, of a different continent, in this case, Africa, the Pearl peoples disappeared by actions carried out by the military. Also, I am including here in this PowerPoint a link to the guidelines as to how to submit a petition for urgent action to a given committee. This was a general overview
comités
of the committee's function, the UN treaty bodies. And then I thought it would be maybe of interest for you to hear about two particular of these specific processes and proceedings I've talked about. First of all, the periodic examination process in order to adopt final observations. The very first one I mentioned. I'll be very concise because Fergus will be sharing his experience. He's been involved in processes to examine reports and send in alternative opinion. But just a word for you to know that this is, well, there's a standard review proceeding and a simplified proceeding. And the standard revision proceeding consists of the fact that the states do submit periodic reviews and reports on how to implement the provisions of the treaty. This means that the states do have the periodic duty to report as to how they are implementing the rights indicated in the treaty and how the compliance is carried out with regard to prior recommendations. As I said, from the moment a state voluntarily ratifies a treaty, is like an obligation and a duty to respect it. Then the committee submit a list of questions or issues to the states. And based on those issues, those specific subjects, there will be action carried out, and the state in question has to submit written answers to this list of issues, okay? So after this dialogue between the committee on the one part and a delegation of a given state on the other part. And this takes place during the sessions in Geneva or online, as it was the case during the COVID pandemics. And then after this dialogue, there's the final observations issued, as well as recommendations. And last but not least, we have the monitoring of compliance, implementing and follow-up of the final observations. So this is like a cyclic process. It's not linear, and when the committee issues conclusions, this is the first step for the next dialogue coming along. A few years ago, in order to simplify the process, they implemented a review simplified process, which is basically the same, but the first step is removed. So directly there's a list of issues drafted by the committees. The committee sends a list of prior issues to the state prior to preparing the report. So the state in question prepares and drafts the report responding to the list of issues. And this is the initial report by the state in question. So how can you participate? When and how can you possibly participate and get involved in this process? When it comes to drafting a report, well, basically at all times. Well, number one, before the dialogue starts, you can indeed submit your written observations before the list of issues is adopted, or even before the dialogue with the state begins. The purpose is like clarifying or contradicting in a way or challenging the information submitted by the state in their official report. Also, you can suggest the committee to ask the state to get into detail regarding some of the concerns In the report, also, you can suggest specific recommendations with regard to a given concern, pointing out the type of measure that should be adopted or who should be responsible for that, and also to identify gaps like recommendations that the state has not complied with and with regard to which there's no mention made in the report. So basically, that would be the way you can get involved, i.e. submitting written information through your own reports that will be considered parallel reports to the reports issued by the states. And there's always the question as to whether or not it would be better for an organization to submit an individual report, or whether it would be probably more relevant to join efforts with other organizations so that can submit joint reports. Now, the advantage of submitting joint reports with other organizations like indigenous organizations will allow some of you who have probably limited resources to get further involved or to get involved despite the size or despite the lack of resources. That's one advantage. Also, another advantage is like reinforcing empowerment on the part of civil society. And a clear advantage for committee is preventing repetition. Imagine if a committee, in order to examine the state, receives 30 reports from civil organizations from the same country, this will necessarily make the process longer and less clear. But on the other hand, for you, the advantages of submitting an individual report is that you can prepare it more swiftly. It doesn't entail negotiating the text with other NGOs, and it also um, uh, skips things like the fact that your organization might not want to submit the report, a general report, but rather a more specific report without the need to get involved in other issues. This was the way you could do this before the dialogue, but you can also participate and get involved during the session, the examination session. You can participate in formal or informal meetings taking place during the session, or you can be observers to the dialogue. You can do a verbal and oral intervention in the formal setting. You can indeed celebrate an informal meeting during lunch. These informal meetings during lunch are very frequent, and sometimes um, this is the place where you can indeed have a more direct approach to the committee members. They say sometimes decisions are made in the coffee shop. So we need to take on board this lunch or coffee moments with the committee members. And you can also participate as observers during the dialogue with the delegation. Last but not least, you can also participate after the dialogue. Once the committee has adopted the final observations, you can indeed do a follow-up and see how the observations are being drafted. You can also do monitoring, you can raise awareness concerning the final recommendations, or you can submit to the committee information about the progress or challenges in complying with recommendations on the part of the states. Before I move on, just to give you very specific examples of how to participate in a process of adoption of the final observations, let me tell you about my own experience. Before I worked here in Geneva, I had the opportunity to participate in the drafting with indigenous people of 3 alternative reports for the organization for the Nations Autochtones, the indigenous people of Guyana. And there were 3 alternative reports, CED and CEDO in 2016, and it was thanks to our own parallel reports that we managed to get very good outcome, because finally the committee did take on board our specific recommendations. In the case of the CED, sorry, the CERD, the Committee for the Elimination of Racial Discrimination, for the first time, the final observations took on board making comments about the situation of indigenous people in the French Guiana. And also the CEDAW, the Committee Against Discrimination of Women, issued a number of recommendations for the French state regarding how the births were registered when they came or happened in the indigenous people community, have to have access to education or health services. And this is something that we never even envisaged when we were preparing this report, the relevance and the impact that we could do beyond the committee itself. For instance, the French National Commission, a consulting body on human rights, absolutely embraced our comments on this consultation process when it came to drafting recommendations for the offshore French states. And they took word per word our recommendations about the fact that in France, indigenous people could not enjoy their rights simply because France was misinterpreting the right of the fact of equal rights and not discrimination. And these are public reports, and this is the reason why we have access to them. When France says that they ensures that all citizens are on equal footing before the law with no discrimination, when the French Constitution says that and says there's the indivisibility of the Republic of France being all on equal footing before the law, this made that indigenous people could not have a collective right. And we said this was the wrong interpretation on the part of France. And this is something that the National Commission on Human Rights took on board. This was not actually our purpose, but it finally had an impact for these alternative reports. And this is why I'm really encouraging you to do that, because you never know what the final outcome would be for the committee. So the second specific process, and I'd like to stop for a moment here, regard how to denounce. That's the one I'm more familiar with because I'm working ever since 2018 in the section of the office receiving these denounces sent to the committee. 8 of the 9 committees have this competence to receive and examine facts that are denounced, basically all of them with the exception of the Commission for Migrant Workers. They're still not functioning, but the other 8 committees are indeed active. This is a very important mechanism that I would encourage you to use when you think that your rights are being violated. The committees here work somehow like courts, international courts of law, like Inter-American or the African human rights system. And in fact, it's very relevant to defend the right of indigenous peoples, even though even in any or none of those 8 treaties, indigenous people rights are mentioned, but through Article 5 of the Convention for the Elimination of Discrimination based on race, you can use the argument of defense of territory, the right to territory, and I was involved with the drafting of this article, the right to traditional territory and free, prior, informed consent in the case of the Sami people and that was drafted against Sweden as a state. They did not acknowledge the competence of CERD, but if this happens, you can take this up to the Committee on Human Rights to Articles 27 or 17 of the International Pact for Civil and Political Rights. And there is recent case law by the Committee on Human Rights against Paraguay, and I was lucky enough to be able to be involved there to protect the Aba Guarani people right against the agricultural products being used, pesticides on their land. There's also the possibility to take up a case on violation of the territory before the CES, the Committee for the Social, Economic and Cultural Right, alleging a violation to Article 11, the right to a dignified place to live, because this is how it is interpreted, this article. And also you can protect the right to traditional property for the indigenous people. So I wanted to talk particularly about this mechanism, because this mechanism is not being used very frequently by indigenous peoples, and yet it can be very relevant. So for you to have a general overview, I am presented that slide, apologies, because the print is kind of very small, but you can make it bigger, you can zoom up. This is a flow chart of how the case by case is taken and examined. Although it's true to say that there are 8 committees, and each one of them has a different working method, different internal regulations, but in a nutshell, the way to approach these cases is very similar in all of them. So you can see that the section for urgent action and petition, this is my team, and this is where I work, and where we get all of these denounces against states. Well, what we do is a preliminary study of the requirements for a case to be recorded. And if the requirements are not complied with, you see on the left, what they're not complied with, we say that this case denounced cannot be recorded. But if it does comply with the requirements, sometimes we ask for clarifications. We prepare an internal document recapping the facts, the allegations, and our recommendations as to how the case can indeed be recorded and why this could be indeed considered a case of violation. And then we send this to the committee. Although I have to say it's not all of the experts that they would be examining this. The 18 experts will not be deciding on the recording of the case. We have the person who is responsible for the presentation, for the submission of the case, or we send it the rapporteur. We have special rapporteurs, and sometimes there's a group of 5 or 6 rapporteurs, experts, and these are the ones who finally decide whether or not a case is recorded and accepted. So if it's finally recorded and accepted, this is a notice is sent to the parties, a letter and a note is sent to the state, informing them about the case being denounced. Generally speaking, committees do prefer to have a joint examination of the admissible nature of the denounce, and then we can talk to the state. We can say that such a case has been denounced, and we give them 6 months to formulate their allegations and the visibility and the essence of the case. Sometimes the committee also asks the state just to submit observations on the eligibility of the case, if it's eligible for acceptance. So when we get the observations from the states, when we get the comments on eligibility and the comments from the victim, then we do draft our decision, and the committee will examine in the next session coming up. Now, if this is a case when the examination on the substance and the eligibility is already done, then we would decide whether or not it's relevant. I will not get into detail, but you will see the flow chart and how this flows, whether it is eligible or not for a denounce. And if it's not eligible, then that's the end of the case. It is closed. And if it's eligible, we send it to the state to formulate their observations on the substance. And the final report is adopted to decide whether or not there was violations. And if there was a violation, the system is quite similar to inter-American or African proceedings. It's like the supervision or implementing step. And then we have like 3 months or 6 months, depending on the type of committee, as to how the provisions and the measures are going to be implemented to make good the case denounced. And this is sometimes not sent to the victim because there's some interpretation, and it remains open until all of the requirements and the measures are adopted to make good the case denounced. Now, when the state has implemented measures like apologizing to the victim, paying for a compensation, even if a general measure is not complied with, like amending a law so that similar violations do not occur, even though that may happen, the committee closes the individual case. But that doesn't mean that they disregard it, because the dialogue with the state continues towards final observations, and they still take this on board, the fact that the law may be amended eventually, and this will be done later on, but the individual case is closed. So very quickly, let me review with you the criteria for eligibility, what we call prima facie eligibility. We, first of all, receive, when we get a denounce, whether the state is part of the treaty. And also, the state should have beforehand admitted the competence and the knowledge of the committee, because only 8 of 9 do have such a competence. And this is important because for a committee to examine a case denounced, the state should have not only ratified the treaty, but also produced a declaration of acceptance of the competence of the committee by virtue of the applicable article, or have an optional protocol implemented. This is an additional test that has been adopted specifically to regulate and govern the examination of cases being denounced. So, number 1, being part of the treaty. Number 2, having accepted the competence of the committee. And these are 2 different concepts that are requirements sine qua non a denounce cannot be examined. Now, there's a list of all the different treaties in chronological order, and you can see in green the treaties providing directly for a denounce mechanism, the CERD, the CED, and the CAT, CRC, and the CED. And then they have to declare an acceptance of Article 14, 22 or 31. And in orange, you see that the committees requiring ratification of the optional protocol. There's also here a list. You can click on there on the link to see whether or not the state is part of the treaty that you are denouncing. Imagine if I took the example of Mexico to provide an illustration of what the ratification was. Now, Mexico ratified all of the treaties, but this is not the only important requirement. There's also another requirement, which is the process to denounce and to complain. Although Mexico has ratified all treaties, Mexico did not accept the competence of two committees to deal with complaint, and this is important before you submit a complaint. Okay, now very quickly, as a second condition to be able to register or record a complaint, we have to double check that victims have indeed exhausted all of the internal resources before they submit their complaint to United Nations. The international law is subsidiary to national law, which means that first of all, the state has the possibility to solve the problem if they so wish, to make good the violation and to act. And if the state doesn't do anything, they can turn to international law, and there is a provision saying that complaint requires to exhaust all of the legal and administrative resources which are available at the state part before you get to the committee, and the person submitting the complaint has to explain exactly what are the measures adopted until they get to the last instance, appeal or final appeal at the Supreme Court. Obviously, there are exceptions. When the processing of cases is too long, internally speaking, or when there is no easy access, when there is fear, when you're complaining about a violation before the same authority that is responsible for the violation, although you may have in theory the possibility, you would not do it because of fear. Also, when there is no efficient dealing with the violation. But the important thing is that if they consider that one of these exceptions is applicable, the committee has to explain why the rule is not applicable to their particular instance. Like the other day, they were talking about interpreters of indigenous people languages. They can say, well, I complained, but I had no access to an interpreter. Although the law in my country provides for me to have an interpreter accessible, in real practice, this doesn't happen. And I had to turn to Castilian Spanish. That would be the second exception. So there's no accessibility.
Está el tema del límite temporal para presentar una denuncia.
We also have to bear in mind the temporary limit. It is important to do things as soon as possible, and there are different timelines. For example, for CRD, there are 6 months maximum in order to get to the committee. For CECR and CRC, there is a 1-year timeline, and for the Committee of Human Rights, there are 5 years. For the other 4 committees, there is no time limit, but the advice is to do it as soon as possible, because sometimes committees think that the applicant is abusing the system when it's filing a report 5 years down the line. We also ask that the report is not presented exactly the same with other instances. So the complaint cannot be submitted at 2 different instances at the same time. The applicant has to choose whether one or the other. And for example, a complaint cannot be addressed to the Committee of Human Rights and the Committee Against Torture at the same time. The applicant has to decide. They have to choose. There is one exception. If you have you went to the Inter-American Court and imagine that it was rejected because it was submitted 6 months after, but you can actually take it to another UN organ, because a treaty body, because there are 5 years for that. Now, who can file a complaint? The rationale personal competency. Well, there has to be a victim, someone who is identified and who has been personally affected. That is the person who needs to file the complaint. So an individual can actually file a complaint. Also, a lawyer can do it, an NGO can do it, an association can do it as well, but under the condition that the victim has given their consent in writing. We are not talking about a very formal consent at a notary public. I'm just referring to giving consent in writing, just on a piece of paper, so that the case can be brought up to a committee. Obviously, there are exceptions. For example, when the person is actually detained or is incommunicado, or where the person has deceased, then we need the consent from his or her relatives. And this is more or less what is needed in order to file a complaint. And I also provided the link to a form to report a complaint, and also some guidelines. You need to know that you don't need to be a counsel or a lawyer at all in order to start this process. And please check the guidelines that I am giving you here in order to get more information. So in order to bring it down to earth a little bit, so that things are not so vague or so abstract, I want to give you some examples of jurisprudence, of relevant jurisprudence in indigenous issues, things that are actually important. I believe that the other panelists are not going to go into detail. That's why I chose these two examples. One of them makes me very proud, is actually a decision adopted by the Committee on against racial discrimination. This happened in April in last year, and it was a victim against Ecuador. I'm talking about the victim, Yaku Perez, an indigenous leader, and got married with a Franco-Brazilian woman, and the marriage took place in a traditional indigenous ceremony. So the marriage did not happen at the civil registry. And the victim explains that for his first marriage, I think in the 80s, he did do it and it was registered by the civil registry. But after the 2008 constitution was implemented, then First Nations started to feel better identified and their rights better asserted in the constitution. So this person decided for his First Nations authorities to officialize the marriage. And this is in agreement with the right to self-determination from indigenous peoples. So the victim brought it to the committee. Why? Because the Ecuadorian authorities actually expelled his wife from the country after some demonstrations took place. So in order to bring his wife back to Ecuador, the victim actually applied for a family regrouping visit, but Ecuador rejected that process because in the eyes of the authorities, the marriage was not legal. Now, the victim argued at the committee the following: not acknowledging the traditional powers of the First Nations, when actually First Nations have been officializing marriages for millennia, even before the construction of the state of Ecuador. When the government is not acknowledging a marriage done in that way, it represents a discriminatory act, and it goes against the right to self-determination of indigenous peoples. And this was the argument submitted by the victim to the UN committee. And the state is actually not condoning the marriage according to indigenous customs, but is not legally recognized. So the civil registry of a marriage in Ecuador is it has to happen within the structure of the state. So Ecuador was actually asking to the victim to get married again, but to do it according to the civil registry rules. And here there was a violation. First, based on Section 1 of Ecuador's constitution that recognizes Ecuador as being a plurinational state. By stating this fact, the government is actually accepting that there are different ways of government and different types of authorities. There is, on one hand, the traditional Ecuadorian state and also indigenous forms of government. And we are actually using the UN Declaration on the Rights of Indigenous Peoples and also the Latin American Declaration. After analyzing all the texts, we see that the right to free determination, indigenous jurisdiction, self-government through traditional indigenous authorities who are actually applying their law is actually an expression of legal pluralism, and this needs to be acknowledged by the state. In this process, we also made some reference to Latin American jurisprudence. The states do not grant rights to, no, they don't create rights for indigenous peoples. No, they have to acknowledge rights that belong to indigenous peoples that are actually predate the establishment of the country itself. And in order to be even more sure, it also analyzed the process of the traditional marriage. Every information was actually analyzed, the free will to enter into marriage, that both were adults, that everything was actually according to international human rights. Now, the decision was important, and the decision stated that against what the state was saying, a marriage performed by indigenous peoples is not going against the jurisprudence of the country. Quite on the other side, is actually helping to implement the necessary cooperation and coordination that should be at the core of the system between Ecuador and the indigenous system. As a redress mechanism, there were several things planned. There were several measures for the victim and also more generic measures. For the victim, the committee asked Ecuador to register in their files the marriage and also to indemnify, to compensate the marriage, the couple sufficiently. And also Ecuador should apologize because of the violation of the rights. Now, in these 3 months, apparently Ecuador already complied with the first redress measure. They actually registered the marriage in the civil registry files. And I think Ecuador is now working on the second one. They are calculating this compensation. And I think Ecuador also did a public apology. And we actually are talking with the victim to double check whether this has happened or not. And also, in order to prevent all this from happening again, we actually asked Ecuador to modify their legislation so that they can actually include the acknowledgement and the registration of marriages that take place under indigenous traditional authorities. And the state should also translate and share in Quechua the committee. And also, there is another case, CEDAW, the Committee on the Elimination Against Women. This happened in January of last year, and this happened against Canada.
No figuran en los tratados.
This is to show you that you can also deal with rights that are not included in the treaties. And I am talking now about the identification as indigenous people. This case was actually about an individual who came on their own, and this person came to the committee and presented their case. It was not a lawyer, it was no expert. I'm talking about Jeremy Eugene Matson. And this person came from a long line of First Nations. His grandmother was taken from the village when she was a child, and she was sent to these residential schools in Canada. These were institutions that tried to reform and convert First Nations to Christianity. Now, this person got married to someone who was not indigenous, and in the eyes of the state, the person lost her connection or her link to indigenous peoples. And now Jeremy Eugene Masson is the grandson of this woman whose whose indigenous identity was ripped. He also lost the fact of belonging to the First Nations. He regained a little bit in 2011, but it was only in 2019 when this person was able to recuperate his full indigenous identity and was able to transfer it to his own children, but with certain limitations, with many limitations. What do I mean with all this? Well, the discrimination against the grandmother that was done back in the day affected all the future generations. So the committee decided that this act was discriminatory against everything that happened in all the subsequent generations. And this was based on Articles 8 and 9 and of certain instruments, and also on the Latin American Tribunal. And in this case, there was an application to amend the legislation regarding the right of identification. And there was a petition to actually re-enable the indigenous identification of all the survivors on the mother's line of the family. 2 days ago, there was a case adopted by the Council of Human Rights, and this will go public in about 2 or 3 weeks. What happened there? We actually were able to develop effective participation of indigenous peoples in national mechanisms of reivindication of ancestral lands. Usually, these are administrative mechanisms when there is land titles involved, etc. But in Australia, these are legal issues. So we actually dealt with it through the right to access courts. We are working on a press release Once the confidentiality stops, we will be able to share it. This is everything I had for you today. Thank you for your time. And if you have any questions, please let me know. And I will also give the organizers a copy of my presentation so that they can send it to you. Thank you.
Muchísimas gracias, Karin, por tu presentación tan
Thank you,
detallada
Karin, for
sobre
such a
trabajo y
detailed
sobre todo
presentation on how UN treaty bodies work. This was really interesting. We are taking note of all your comments in the chat window and also in the Q&A function of Zoom. I would love if we could actually answer all the questions at the end. And this is also to give interpreters a little bit of a break since it's been quite intense so far. So dear brothers, sisters, why don't we go ahead and take the break now? It will be a 20-minute break, but we will take note of all your comments and all your questions, and we will have time to answer them at the end. Please do not disconnect if you don't want to. Just keep the Zoom going. We will just break for 15-20 minutes. Please keep sending us questions. We will try to answer them in the chat, and some will be answered at the end. So see you in about 20 minutes. Thank you.
Muy bien. No sé si nuestros intérpretes están listos.
Very good. I don't know if interpreters are ready there. We have to thank you for waiting for us during this break. And I am actually starting 2 minutes ahead of time because I would like to clarify a couple of things that came up in the chat window. There are several of you who asked if we will be sending the presentations. Both the presentations and the recording of today's training session will be available on the website. I will actually copy paste the link in the chat window. That way, you will have the access to all of this information. As I already mentioned, we are providing interpretation to several languages. So all presentations will actually have their translation. And now let's continue. Thank you, Karine, for the presentation. I now would like to introduce to you Fergus Mackay. Fergus will present today about his experience on the use of UN treaty bodies regarding indigenous peoples. I will actually switch to English in order to provide a short description of Fergus Mackay.
Council at the Indigenous Peoples' Rights International, IPRI. IPRI was established in 2009 to lead and coordinate the global initiative to address and prevent criminalization, violence, and impunity against indigenous peoples. Prior to that, he was a senior counselor at the UK-based NGO, the Forest Peoples Programme. He has engaged with the UN treaty bodies for over 30 years and litigated various cases before the ILO, the Inter-American Commission and Court on Human Rights, including the Saramacca people in 2007 and Kaliña and Lokono peoples in 2016 cases. It is a great pleasure for me to give the floor to Fergus, who will now continue. Thank you, Fergus. The floor is yours.
Thank you, Arturo. And thank you to the Voluntary Fund for organizing this, co-organizing it. Good morning to everybody in my time zone. Good afternoon to all of you in Europe and elsewhere, and good evening to those of you elsewhere. I'm going to try and do 3 things today. One is give you a short overview of the history of how we got from say 30 years ago to now and what the differences are. And there are a lot of differences. I'm going to talk a little bit about strategic thinking and why you would go to one treaty body versus another, or why you would go to the treaty bodies at all versus a regional mechanism if you happen to have access to that, right? Regional mechanisms would be the Inter-American Commission and the African Commission, and the Inter-American Court and the African Court. There is a thing in Asia, but it doesn't do very much, so I'm not going to talk about that one. So the main regional mechanisms are really African and American. The one in Europe doesn't really do indigenous issues very well, even though people have tried a number of times. So I'm not going to talk about the European Court, even though some people, Sami in particular, and Russian indigenous people would have access to the court. So I'm not going to talk about the European Court. I'm also going to talk a little bit about some of the jurisprudence, but not in any detail. So I'll start with the history, the overview of how we got to where we are now. As Arturo mentioned, I've been doing this for about 30 years now. And when I first started, in the late 1980s, early 1990s, there were very few cases around at all. There was one Canadian case, Lovelace versus Canada, decided in 1981, which was an important case, albeit started out as a gender discrimination case and was converted really into a minority rights case. And that case was about Sandra Lovelace, who married a non-Indigenous man and lost her rights to live on her reserve where her people live. In fact, the only place her people live is on that reserve, and she was denied by Canadian law, the Indian Act, which was also at issue in the Matson case mentioned by Karine earlier. So Canadian law says if you married a non-Indigenous man, as an Indigenous woman, you lost your rights and your descendants lost their rights to continue to live on the reserve. The same did not apply, however, to Indigenous men. The committee ultimately decided that case on the basis of minority rights, Article 27 of the International Covenant on Civil and Political Rights, on the basis that culture can only be enjoyed with other members of that culture. And if they only live on that reserve, denying her the right to live on the reserve was equivalent to denying her the right to enjoy her culture together with other members of her collective, her people, right? So that was kind of the only case that was around when I first started. And I remember going to meetings of the working group that was developing the UN Declaration on the Rights of Indigenous Peoples. And there was very little jurisprudence that could be used to substantiate some of the advocacy that was taking place there. The next case is another Canadian case, Omanayak versus Canada, and that was in 1990. And Omanayak was a pretty positive case. It involved large-scale environmental contamination of the traditional territory. Omanayak was the chief of the people affected, and he brought the case arguing that the denial of control over their traditional reserve, their traditional territory, and large-scale pollution by loggers and paper mills and the like, violated his rights to self-determination and to enjoy his culture in community with other members of the group. The committee rejected the self-determination argument on the basis that the optional protocol only allows for complaints about Articles 6 through 27 of the International Covenant, and self-determination is in Article 1. So only individual rights could be argued under the optional protocol as formal cases before the committee, right? So they threw out the self-determination argument and found, quote, that persons, Indigenous persons, have the right to engage in economic and social activities which are part of the culture of the community to which they belong, close quote. So this was their way of kind of dealing with land rights issues without dealing with land rights issues, basically by saying that people have a right to hunt and fish and do other activities that are part of their traditional economy. And the implication, of course, being that that would then require protection of the land base within which that took place. But they didn't go that far, and they didn't actually say that. It wasn't until 1994, in fact, that the Human Rights Committee actually started dealing with land issues under Article 27, and that was in a general comment. I remember Karine said that one of the functions of these committees is to interpret the treaties they're responsible for, right? So they adopt general comments or general recommendations generally to do that, yeah? So the first time they did that was 1994. And it basically said that in some cases, culture is directly related to a way of life that involves the use of land resources, might include traditional activities like fishing or hunting. and, quote, the right to live in reserves protected by law. Even went so far as to say that might require specific and positive legal protection and measures by the state, which are developed with the effective participation of members of the community, right? So this is 1994, and it generally, you know, those were not bad decisions. They were positive in the sense that they broke open new space and new ground, but they didn't really get to the heart of the matter of what most people were complaining about. And then we had approximately 15 years of absolutely abysmal decisions coming from the Human Rights Committee, particularly in a line of cases filed by Sami people from Norway, Finland, and Sweden, one of which was Kittok versus Sweden. Another one was I landsman, and then there was L landsman, and then there was two landsmans, and then there was another landsman, all of which were complaining about logging and mining that were affecting their rights to self-determination and to enjoy their culture under Article 27. The committee was pretty forthright in saying that their right to culture included the right to reindeer herding, which is a fundamental part of their traditional economy and their way of life. But it rejected over and over again that the activities authorized by Sweden or Finland or Norway or whoever it was didn't rise to the level of actually violating the rights under Article 27 based upon the language of that article, which the relevant part of the language is shall not deny. So they established a test where you had to go, it couldn't be a mere interference with the right, it had to deny the exercise of the right. So we had escalating activities, logging, more logging, mining in a sacred mountain, various other, all of which were deemed not to be sufficient to constitute violations. Those cases were depressing, to put it mildly, and dissuaded a lot of people, myself included, from even bringing cases to the Human Rights Committee. It was felt that it was not particularly fruitful to even try. That started to change in 2000 when a case was decided against New Zealand called Epirana Mahaika. And the Mahaika case was the first time that the committee really went beyond the individual rights framework and started to conjunctively read
Aquí empezó una lectura conjunta.
Article 20. Sorry, I'm getting Spanish coming into my ears. So that in that case, they started reading Article 27 conjunctively with Article 1, the right to self-determination. That case involved Maori fishing rights, and particularly commercial fishing rights around New Zealand, and whether Maori were entitled to a quota of those fishing permits that were being issued by the New Zealand government. And if so, on what basis and how? And the committee came up, albeit in not the main ruling in the case, came up with a test that has since really been adopted by the African Court, the Inter-American Court, and others, that respecting Indigenous people's rights under Article 27, when read in conjunction with Article 1, requires effective possession and effective control over the lands and resources traditionally owned by Indigenous peoples. So that case really marked a bit of a turning point insofar as they began to collectivize rights, but also started getting into more detail and more substance in terms of what those rights were. And effective possession and effective control over lands and resources is a key element of self-determination, Article 1. Yep. So I'll tell you about some of the more recent cases later. And what you'll see is there's really night and day, particularly in the last 5 to 10 years. I would say even the last 5 years, especially. But I do a compilation of the outputs of all of these treaty bodies every 2 to 3 years or so. So I have a pretty good overview of what they're all up to and which ones are doing new things and which ones are doing better things and which ones are doing worse things sometimes. So it gives a good idea of if you're thinking about where to bring an issue. It tells you go to this one or don't go to that one or go to both of these but do it in a slightly different way, right? So the strategy of using the treaty bodies is actually really, really important. Obviously, you need to know how they work. Obviously, you need to know how they work, and you need to know what you can do with them. But there's also strategic thinking about which ones might be more important versus others, right? And also, there may be different reasons why you want to go to them. There may be a specific case you want to complain about. Or there may be a general theme that you would like to advocate across the UN system, treaty bodies included, right? I'll give you an example. So when we talk about the declaration, the UN Declaration on the Rights of Indigenous Peoples, oftentimes the response back is, well, yes, but none of that's binding. It's all in a declaration, and we all learned in law school that declarations are non-binding. So you can talk all you like about the UN Declaration on the Rights of Indigenous Peoples. We don't care, basically, is the response. Oftentimes, yeah. Sometimes there's a bit of nuance in there, but usually that's not binding. We don't have to do that, right? How might you address that strategically? Well, there's a number of ways. One of which is to advocate that the treaty bodies begin to read the declaration into their interpretations of the binding human rights instruments that each of them is responsible for, right? Can they do that? Yes, they can do that. And in fact, they're doing it on a regular basis now. And that's perhaps the biggest change that's taken place in the last 5 years, maybe 4 to 5 years. I'll give you one example. This is from a General Recommendation 39 adopted by the Committee Against Discrimination Against Women, right? The Committee on Discrimination Against Women. General Recommendation 39 is on the rights of Indigenous women and Indigenous girls. If you'd asked me 20 years ago whether it was a good idea to ask CEDAW to do that, I would have said no. I would have said, don't go anywhere near that committee. They keep saying things like Aboriginal women in Australia should all be given individual land titles. It was a very, it was a treaty body that didn't really understand Indigenous people's rights in any sense, at least in my opinion, right? So on the declaration status, General Recommendation 39, which was adopted in October 2022, states unambiguously, and I quote, that the committee considers the UN Declaration on the Rights of Indigenous Peoples to be an authoritative framework to interpret state party and core obligations under CEDAW. All of the rights recognized in the declaration are relevant to Indigenous women, both as members of their peoples and communities, and as individual Indigenous women, and ultimately in relation to the guarantees against discrimination in CEDAW itself. So what have they done there? And I would note they didn't do this by themselves. They did this because that approach was advocated before the committee, right? So what have they done here? They've basically said that the UN Declaration on the Rights of Indigenous Peoples is, quote, an authoritative framework to interpret state party and core obligations under CEDAW. What they've done here is they've said that the declaration will now be read together with CEDAW to interpret and understand and enforce the rights of Indigenous women and girls, not as distinct from their communities and peoples, but as members thereof, as well as individuals, right? So if they actually do what that says, they're essentially converting the declaration into binding standards through the lens of CEDAW, which is a binding treaty, right? Is CEDAW the only one that's done this or is doing this? No. The Human Rights Committee is doing it. The Committee on the Elimination of Racial Discrimination is doing it. The Committee on Economic, Social, and Cultural Rights is doing it. I would say probably 6 out of the 10 treaty bodies are now doing this on a regular basis. And if you look at what these special procedures are doing, there's special rapporteur on this and special rapporteur on that, they're all doing it too. So there's this collective approach, maybe collective is the wrong word, becoming a collective approach in the UN to read the supposedly non-binding Declaration on the Rights of Indigenous Peoples together with the various binding treaties that these treaty bodies are responsible for, right? Let me give you one example that some people might think doesn't actually happen. This is the Committee on the Rights of Persons with Disabilities. This was also in 2022 in September. It adopted a concluding observation on New Zealand's periodic report, in which it recommended that New Zealand, quote, develop legislative and policy frameworks that reflect the Treaty of Waitangi, the Convention on the Rights of Persons with Disabilities, and the United Nations Declaration on the Rights of Indigenous Peoples, to ensure that Maori persons with disabilities are closely consulted and actively involved in decision-making processes, and that their right to self-determination is recognized. For that committee to say that is pretty impressive, but it's part of a larger body of work that's going through the UN. So strategically, there was a decision that we need to get these treaty bodies to start talking about the declaration in a more constructive way than some of them had before, right? The Human Rights Committee is now reading it together with Article 27. Remember those dreadful cases, the Sami cases, where it was never enough to establish a violation? They're now reading Article 27 together with Article 1 and explicitly with the UN Declaration on the Rights of Indigenous Peoples. And they're doing so in case law under the optional protocol, right? As well as in their concluding observations and in their general comments and general recommendations, right? So strategically, why would you choose one committee versus another? Well, there's very good reasons. One of them obviously is that you want to talk about children's rights, so you would prioritize the Committee on the Rights of the Child. But you should also know that there are other committees that also deal with children's rights and may do so in a different way, or perhaps even a better way than the Committee on the Rights of the Child, right? If you'd asked me 15, 20 years ago where to go about Indigenous women's rights, I would have said go to the Committee on the Elimination of Racial Discrimination rather than CEDAW, simply because they were dealing with Indigenous women's rights in a much better way than CEDAW was, right? You may want to choose a committee because you want more back from it than you might get from another one. What does that mean? So if you submit a report to the Committee on the Elimination of Racial Discrimination under its reporting procedure, you're likely to get concluding observations that have 4, 5, 6, 7 paragraphs and recommendations dealing with Indigenous issues. If you do that in the Human Rights Committee, you're likely to get 1 paragraph back and 1 recommendation. Now, maybe the 1 recommendation is what you want, all good, then use that one. But if you want a larger amount of response to your input to the committee, CERD, the Committee on the Elimination of Racial Discrimination, is by far the best place to go, simply because of the detail they'll get into that you won't get from most of the other committees. That one is followed by the Committee on Economic, Social, and Cultural Rights, which you'll probably get 3, 4, 5 paragraphs recommendations back from. compared to most of the others where you're likely to get one, or a mention where they make lists of things like, and be nice to these people, brown people, black people, green people, indigenous people, those people, these people, right? So some of them like making lists where they chuck the word indigenous in, but it doesn't actually mean anything in practice, right? You may want to go prioritize the Committee on the Elimination of Racial Discrimination simply because it's easier to interact with that committee. They have, as Corinne mentioned, lunchtime briefings, normally right before they talk to the state, where the committee members will, sometimes most of them, occasionally all of them, but certainly some of them will come sit in a room with you for an hour and you can talk to them and they'll ask you questions. And that all happens before they talk to the state. So you have a very good opportunity for briefing the committee before it even talks to the government, and in a way that enables a meaningful back and forth dialogue and question and answer that you don't normally get elsewhere, right? So we know from the track record, from the jurisprudence, the precedents of the various committees, which ones tend to be better on Indigenous issues versus others, right? So again, it depends what your motivation is for going there as to why you might choose one or the other, but CERD is very good on Indigenous issues and has been for a very long time. And you will get a lot back going there versus some of the other ones, right? Now, that doesn't mean the other ones are not any good. I was recently asked to think about the Committee Against Torture, in part because the mandate of IPRI, the organization I work for, is dealing with issues of criminalization and persecution and impunity. And that means the Committee Against Torture is perhaps an obvious place to go, even if a lot of people think it only deals with torture. It doesn't. So I'm gonna, if I can figure out how to do this, I'm gonna share my screen. So I went through the jurisprudence of that committee, the Committee Against Torture, mainly to see what they've done previously on Indigenous issues, and where there may be opportunities to engage with them and to further develop Indigenous issues within that committee, right? So this is just a list of what I came up with through a very quick review of just some of the more recent jurisprudence from that committee, right? So they deal with issues involving violent attacks against Indigenous peoples, lack of investigations. They deal with the underlying causes of this. Is the state seeking to address underlying causes of these attacks? They deal with attempts to criminalize Indigenous peoples and stigmatize defense organizations, including through the use of anti-terrorism legislation or sedition legislation or whatever it happens to be, right? Has the state adopted a specific policy for the protection of human rights defenders, especially those defending the rights of Indigenous peoples? Enforced disappearances of Indigenous peoples and Indigenous leaders, yeah? Indigenous people and Indigenous leaders. Use of force against demonstrators, treatment of Indigenous people in the criminal justice system. Is there any attempt to address disproportionate imprisonment rates for Indigenous peoples? They deal with a whole range of issues related to denial of remedies and impunity in relation to Indigenous rights, including in relation to land rights, including non-consensual transfers of lands to third parties for agriculture or resource exploitation, including involuntary displacement. And denials of remedies are being conceived of as part and parcel of the right to humane treatment. So where there's an extended and prolonged denial of remedies, this is being looked at as under Article 16 of CAT, which is about the right to humane treatment and the prohibition of cruel and inhumane treatment, right? That got me thinking in many, many different ways about the potential use of that committee, right? They deal with gender-based violence against Indigenous women and or forced sterilization. Unfortunately, that is still a thing these days, right? They deal with the operation of Indigenous justice systems and how they relate to the justice system of the state. Reconciliation, apologies, the legacy of serious human rights violations. The operations of private security companies, forced evictions, forced labor. I mean, basically this committee does almost everything all of the other ones do under the heading of torture, right? So to me, that means there's, we need to be paying more attention to that committee and we need to be doing more things there. The question is then how and why and in what way, right? But if you don't know the jurisprudence, you wouldn't think perhaps of going to this committee simply because it's not a, it's under the label of torture. And if you're not dealing with torture, as most people understand the term, you're probably not going to go there, right? Yeah. All right. So I wanted to talk a little bit about where we are now. And the short answer on that one is we are night and day from where I started 30 years ago, where we all were 30 years ago. Insofar as the treaty bodies are dealing with Indigenous issues in a way that they weren't before. They're dealing with collective rights issues in particular in a way they weren't before. They're also reading self-determination where they can into their decisions. At least 5 of them have specifically invoked self-determination, 3 of them where it's not even in the treaty they're responsible for, right? CERD is doing it. The Committee on Disabled People, on people with disabilities, persons with disabilities. The Committee on Economic, Social, and Cultural Rights is doing it. CERD is doing it and has been doing it for quite a long time, actually, since the 2000s, but the early 2000s. But it's now doing it not only in its concluding observations, it's doing it in its case law. And this is very, very recent. This is 2018, 19, 20, 21, 22. There's been a dramatic change in how these committees are processing cases, in particular against them, against member states, and how they are reading collective rights, the UN Declaration, together with their with the primarily individual rights that are in their treaties. So they are actually doing what people used to cite as the justification for why a declaration is needed, because they weren't doing it before. And what they weren't doing before was conceiving of Indigenous people's rights as self-determination, as collective rights, as property rights in relation to traditional territories, etc. And the argument always was a declaration was needed because of this individual rights bias within the Human Rights Treaty framework. That's now come full circle to where they're basically doing collective rights, self-determination, et cetera, within the context of those individual rights treaties. And they have reinterpreted those treaties and still are reinterpreting those treaties to recognize that Indigenous peoples have collective rights and those rights are enforceable against governments, right? That's a big, big change. And it's not only getting into what some people consider minor issues, but it's getting into whether Indigenous peoples can maintain their own justice systems, their own legal systems, whether Indigenous peoples get to choose without any interference who their legal representatives are, and their own institutions, and the requirement that the state recognize those institutions and respect the decisions of those institutions. They're getting into issues of free, prior, and informed consent, going beyond consultation as the applicable standard in most cases. The Human Rights Committee in particular first did this in 2009 in a case called Poma Poma versus Peru, where it said that consent was required where there were significant impacts on traditional cultural activities, whether it's hunting, whether it's fishing, whatever it was, whether there are impacts on indigenous lands also, right? The committee's reaffirmed that some 3 times since then, most recently in, I believe 2021, the Paraguay case, which I'm not sure if Karine spoke about that, but if she didn't, it would be good to talk about it, because that case reaffirmed that free, prior, and informed consent standard as the applicable standard for engagement with indigenous peoples, right? We also have, cases involving the Sami, which are now looking at the relationship between the Sami parliament as the entity that gives free, prior, and informed consent on a national level for the Sami, and how the Nordic governments don't get to decide who are members of the Sami parliament because they were trying to do that. And there's 3 cases recently on that, all of them against Finland, 2 of them in the Human Rights Committee and 1 in CERD, all of which very forcefully push back against the idea that the state has any business defining who is a member of the Sami parliament or not, and tied that very clearly to the declaration, to self-determination, and other rights within those the various treaties, right? So we've really got to the point now where these treaty bodies could and likely are effective mechanisms, at least for articulating rights. Now, the enforcement aspect is a perennial problem, which no one has figured out the answer to. I have 3 judgments, binding judgments of the Inter-American Court against one country, none of which have been implemented in going on 20 years in one case, right? So getting decisions doesn't mean it fixes your problems, right? I saw an email, a message above from someone in Nepal talking about the Kathmandu Valley and forced evictions of indigenous peoples in the Kathmandu Valley. I know that situation because I worked with a Nepalese organization to file a case with the International Labor Organization. And the ILO was processing that case while the government of Nepal threatened the labor union that filed it with imprisonment for treason if they didn't withdraw it. And they withdrew the case. And the ILO said nothing, nothing at all about any of that, right? So the implementation and the enforcement of these things is a major challenge, right? That said, there are successes, and you'll hear about it, one of them in a minute. And I want to stress that it would be irrational for people like me to do this if it didn't work sometimes. It does work sometimes, and not just on a jurisprudential level, right? The urgent action procedure of the Committee on the Elimination of Racial Discrimination is a very easy thing to use. It's basically a glorified letter that you send in. You can do it 3 times a year, coinciding with each of their sessions each year. I know at least 3 instances where it has resulted in positive change at the national level. In the case of Suriname, they stopped adoption of a draft mining law on the basis of objections raised by CERD in the urgent action procedure. In Papua New Guinea, they rejected an entire class of large agricultural licenses called SABLs. I don't remember what it means, but essentially the government withdrew the law establishing these SABLs on the basis of a CERD urgent action process, right? So there are a number of examples of positive change that comes about from using these things. The important thing to do is to use them intelligently and not just use them for the sake of it, right? So in that sense, understanding what they do and what they've done is very helpful in informing you as to what you can do with it. And I encourage everybody to try it, but to do so in a very strategic and intelligent way. I'm going to stop now because I'm encroaching on the time of my colleague Vincent, who's following me. But if you have any questions, more than happy to answer them, whether it's in writing or in the question and answer period. Thank you.
Thank you so much, Fergus, for your very comprehensive presentation. It's very interesting to hear you about all the experience you have had presenting cases to the mechanisms. I think, I mean, we do appreciate it a lot. It's very rich. There's a lot of experience that you can share. And well, unfortunately, yeah, we won't have enough time to share all the information that we have, but that's why we have the chat function. I'm sure that you will also take a look right now to the questions. There are a number of questions to you, Fergus. So if you can go and try to answer to some of them, that would be good, because unfortunately, we won't have time at the end to answer to all the questions online. So thank you so much again. It was a really great presentation. And now I want to give the floor to Vincent Ploton. Vincent leads the International Service for Human Rights Strategic Engagement and Litigation with the UN treaty bodies. He has supported and facilitated engagement and advocacy with all UN human rights mechanisms, including the Human Rights Committee, the Subcommittee on the Prevention of Torture and Committee Against Torture. Vincent is a member of the advisory board of the Oxford Journal of Human Rights Practice and the Land Rights Now campaign. He has worked with indigenous communities in Colombia and Bangladesh, and more recently in French Guiana. He also worked for NGOs and UN agencies in South and West Asia and Colombia. Vincent holds a MSc in political science from the University of London and an MBA from Lyon, France. Vincent, you have the floor. Thank you so much.
Thank you, Arturo. Thank you very much. I have been asked to speak in French, donc je vais passer au français.
So I'll switch to French now. Thank you to the High Commissioner and all organizers of this session. It's a great privilege and a great pleasure to share my experience with you. My presentation will focus on one of the committees we discussed. Fergus and Karine mentioned it. It's the third, the Committee on the Elimination of Racial Discrimination. I will now share my presentation. I believe that you can all see it now. I hope so. So the first thing that I wanted to remind everyone is the place of this committee. Karine did a great job in presenting all the treaty bodies, the committees, and their various mandates. Fergus illustrated quite thoroughly how it's evolved during the past years to integrate the indigenous issues and all the tools that are available to the indigenous peoples. My organization is a global organization supporting all human rights defenders, and we are working with indigenous defenders. We usually present the treaty bodies as one toolkit. It's a toolbox, really, because there are various tools within these treaty bodies. You can use the various alerts, warnings, as we've seen, or urgent actions, or the periodic reviews, as we've mentioned before. So there is a large choice, and you can select the most adapted tool to your situation, given your context on the ground at the community level. So on this first On this slide, you can see the 10 treaty bodies, and I would like to speak more specifically of the Committee on the Elimination of Racial Discrimination. It's the most ancient, it's the older committee, and it's one of the most relevant for Indigenous people rights. Many of you might recall that the former president, Francisco Calixay, is now the special rapporteur for Indigenous people's rights. So it's an ally. It's a committee that can be considered as an ally for Indigenous peoples, and you will be able to work with this committee quite deeply. In this presentation, I want to share how we supported an Indigenous community to obtain quick and urgent action with the committee. First of all, there is this short video. It's an introduction to the CERD, and it was created by the UNHR. So let's.
Voilà, donc on passe à la diapositive.
There you are. So next slide. As I was mentioning, I'd like to speak more specifically about the early warning and urgent procedures. Karin already explained what it is about, and Fergus gave us at the end of his presentation some examples. I believe that he mentioned 3 cases in which he saw positive impacts, positive results. I believe that this one committee, the third has this mechanism. It was implemented in the 90s during the Yugoslavian conflict. It's a conflict during which there were tensions between communities, and it's procedure that was implemented at the time. It was very innovating. To this date, it's one of the most used procedure by Indigenous peoples. During the 3 annual sessions, they adopt many decisions, and I strongly encourage you to use this procedure. It's a very useful procedure. If, of course, you conform to the various criteria. And I will give you the example of French Guiana. When we talk about early warning and urgent procedures, what are we talking about? Well, early warnings are situations in which we try to prevent a violation. For example, and it was the case in French Guiana, when a permit is about to be issued for a dam or a mining project or another large project which did not get the consent of the communities. I'm talking about the free, prior and informed consent, of course, of the communities on which territories this will be happening. This consent should be obtained before the permit is delivered. When an extracting or development project is planned on indigenous territories, there might need an urgent intervention of the states. Here on this slide, I showed you the internet's web page of the committee, and there are three types of measures of interventions that the committee will decide on. It will either adopt decisions, publish statements, or send letters to the member states. The decisions are for the worst cases. Statements or letters are for mild cases. If there is an example of a decision for the situation in Xinjiang, for example, with violations linked to forced imprisonment, independent experts had examined this situation, and the committee adopted a decision referring this situation in Xinjiang to the Under General Secretary to prevent genocide. So it's a major intervention from the committee with no precedents. It's the first time that the committee decides to refer this situation to this level. Which is important to mention is that this decision about Xinjiang happens after two other actions, two other interventions in the past. If you are facing a refusal from the committee to adopt an emergency intervention, don't let go. You can insist, please. It's not because you failed once that you will not succeed in the future. Try to assess what did not work, what worked. Try to get some allies, identify who are the members of the working group within the committee, because there is a working group on early warnings and urgent procedures. I believe there are 5 working groups, and it might be interesting to know who's working on which group, and possibly to share information, or at least make sure that the information you transferred reached them. So I strongly encourage you to visit their web page, where you can see examples of the various decisions, statements, and letters that have been done by the committee. Unfortunately, the committee does not publish the answers received from the member states. It's a shame because organizations who submit early warning or urgent procedures do not get response from the member states, but it does not mean that there will not be results. On the next slide, I'd like to show you a very brief video introducing the case of the early warning in French Guiana. It's a very short video.
Alors, il semblerait qu'on ait une petite difficulté avec
Seems like This video is not working, so I will go directly to the next slide. So I'll give you more details about this case. This case is presented here. So it was an early warning procedure request submitted to the committee by indigenous communities from Guyana who were opposed to a great mining project called Montagne d'Or, Golden Mountain, on their lands. Interestingly, France, the state party, investigated and consulted with the whole population of French Guiana, including indigenous peoples, but did not take into account that the territories were ancestral indigenous lands. So the community of indigenous organizations of Guyana submitted this early warning procedure. And the committee wrote to France to ask them to re-examine, to reassess their consultation process. But France said we had the consultation process, and the committee replied that the indigenous people's consent was not given. And they asked them to stop or suspend at least the project. So I invite you to go to our ISHR Academy, and in this online module, you have all details of this complaint that we supported. There are all documents, including the complaint that was filed. So you can see precisely how an early warning procedure is carried on. Then there is here the structure of the document. So as you can see, it's a short document. There are about 10 pages. We introduced the context, then we presented the project itself. We documented very solidly the opposition from the indigenous peoples. All agreed against this project, and the fifth part was more legal and explained how this was a violation against the convention. And finally, we asked the committee to carry on an early warning. I would like to come back to what was said by other speakers. It's not necessary to be a lawyer or a legal person to do this. In this case, it's a beneficiary of a fund in Guyana, a student who was a direct directly impacted by this project, and you have all legitimacy to submit these procedures. You don't have to be a lawyer or legal practitioner, legal expert, because we supported, for example, the indigenous organization from Guyana in this procedure. I wanted to show you how the early warning looks like. So in December 2019, we submitted our request in October, and then the early warning was adopted shortly after that. So you can see here that the committee is writing to the representative of France in Geneva in sharing its concern about this project and asking to review the consultation and suspend the project. Which is interesting here is that ONAG or my organization did not do any request for follow-up, but the committee did it on its own. December the following year, the committee wrote to the French representative again. The project had been suspended, but the committee deemed necessary and relevant to follow up. So there is a follow-up. It's not the case for all early warnings or urgent actions, but in this case they did. It was the first early warning of the committee for something happening in France. Some on the French territory, for something happening on the French territory. Some practical tips. This you can find on our online module ISHR Academy. It's available in 3 languages, in French, Spanish, and English. I invite you to consult it and go through it. A few practical tips. First thing, and maybe the most important, is to get familiar with the way the committee work with their guidelines. There are instructions. You will easily find them online, and these instructions help you submit your requests for early warning or urgent procedure. And if you submit this kind of request to other committees, for example, the CED, it's important to follow their instructions. We also created a link to early warnings or urgent procedures. Go check out what the committee did in the past, what was adopted, what kind of decisions they made, what kind of actions or measures were done in the past. If need be, try to discuss with members of the committee. There might be members in your country. Some of you may know them, and some committee members, their contact details are available. You can reach out to them, you can contact them, and it was the case. We did it informally. All committee members do not wish to answer questions, but some of them are open-minded, some of them are open to discussions, some of them are interested by Indigenous issues, some of them are Indigenous, and it can really help you and guide your strategy. Next point is that it's important to work with the media, to leverage on the media. In the case of French Guyana, it made a huge difference. Le Monde, which is one of the main newspapers in France, published an article about this decision, and it was really important because it gave visibility. When such a newspaper published an article about a topic other newspapers usually follow, and so we prepared a press release with Indigenous organizations from French Guyana. We made sure that we contacted various journalists, and we briefed them beforehand. So having a clear communication strategy with the media is key, because unfortunately committees have a very limited ability to give their decisions visibility. Of course, the HTHR has a communication unit, but you must get as much visibility as possible, because within the United Nations, many decisions are adopted at once, and the impact might be limited. Unfortunately, the early warning procedures of the third do not get the attention of the media. So you have a role to play to make sure that at your level, in your communities, in your country, at the regional level, this decision adopted by the committee is visible and gets the attention. Something else that I wanted to mention, that beyond traditional media, we'll try to reach out to radios or blogs. Here is an example of the how this scholar submitted this request, and he discussed it with various journalists. As you can see from these examples, the decision of early warning was one of the main criteria resulting in the suspension of the project. About 4 months after the early warning decision, the president announced that the license for the mining project was rejected. At first, there was suspicion, the indigenous community were suspicious that maybe this was not for good, and that the project would go on eventually, but the Canadian, and it was a company from Russia and Canada, and it was completely stopped for good. So the visibility, or at least the fact that the decision of this committee was visible at the national level through the media, probably contributed. It's one thing amongst others. Of course, it's not the only reason behind it. There were many critics in various organizations by the civil society. There were many reasons to reject this project, but it was a tool. The media were a tool which contributed to raise the voices against this project. Of course, this project also had some support, especially from the private sectors and economical interests. Many were favorable to this project. It would bring, it would be, of course, cost effective for them. But a treaty ratified by France, and if an expert committee asked the government to suspend this project, it played a key role. Of course, unfortunately, it's not always the case.
La situation, j'ai parlé du Xinjiang et de la décision du comité qui a été adoptée récemment envers le Xinjiang. Bon, vraisemblablement.
Earlier, I talked about Xinjiang, the decision from the committee, but for now, we don't have much visibility on the potential impact on a country like China, which denies those allegations of violation. But in certain contexts, it is necessary to give visibility to the committee's decision, and then it's up to you to use those committee decisions to make them known to the local authorities, to the national authorities, and highlight to them that the authorities are obliged to take into account the requests of the committee, because once again, Karine said it, those committees have been created based on treaties that have been ratified by the states. So they have a binding aspect, which gives power to the decisions of those committees. I will stop here on the French Guiana's case and this fast alert, which allowed us to have this mine d'or project suspended in French Guiana. I wanted to take the opportunity to tell you that in my work, I've had the opportunity to work with the Juma community in Bangladesh, the Umma community in Colombia, and also the Kalash community in Pakistan. So if some of you come from those communities, I just want to say hello to you, and I look forward to working with you potentially. My organization is a generalist organization, meaning we work with all human rights defenders throughout the world, but we have a specific program on environmental defenders, through which we work a lot with indigenous defenders, and we remain available to support any project you might have, any complaint you might have to the committees, including urgent action or fast alert request to the committee on the elimination of racial discrimination. To conclude, do not hesitate. You don't need to be a legal expert, and you don't hesitate to contact the committees. Some sometimes feel that they are hard to reach, but you can reach them. You can contact them. They're allies. So do not hesitate to do it. And you can do it through allies such as Fergus, the High Commissioner, or my own organization. Thank you very much. And I will give the floor back to Arturo. Thank you so much. Thank you very much, Vincent. That was very interesting.
Thank you so much. Thank you for this very large, interesting and detailed explanation about your own personal cases. It's very enriching in order to add matter to the discussion today. We have like 10 minutes ahead before we put an end to this session. I'd like to read a few comments and questions for the panelists that we've been receiving throughout the session. I will not mention the person who says whatever is said or whatever is mentioned, so that we have more anonymous comments with regard to the legal pluralism and with regard to the mechanism in the treaty. How is it possible to guarantee human rights in systems acknowledging legal plurality when the legal decisions for indigenous peoples are unfair and the state is bound by legal mechanisms, and yet they do not make or take any action in that regard? I think this question is very interesting, and I'd like to ask Karine, Fergus, or Vincent if any of you would like to make a comment with regard to that question.
Did I understand the question correctly, that it refers to the worldviews or representations enshrined in international treaties and the extent to which they include or do not include indigenous legal systems and representations? Is that
no, the question is more, what can indigenous peoples do, or what can happen when indigenous peoples' systems, internal systems, take an unjust decision within the community? And at the same time, of course, member states need to comply and respect these indigenous peoples internationally or with the member states. So it's about the juridic pluralism. It's like a clash between the system, the indigenous people's justice system, and the obligations of member states nationally and internationally, and with its own legal framework. If you want, I can give you some time to think about it. This question is for Fergus. In relation to early marriage, which is allowed in exceptional circumstances in some indigenous cultural communities, how do we reconcile treaty obligations, eliminating
Arturo, I think we'll.
Yeah, please, Vince.
No, sorry, I think we lost you for a second, but you're back.
Oh, I'm sorry. Should I repeat the question? Yes? Okay. In relation to early marriage, which is allowed in exceptional circumstances in some indigenous communities, how do we reconcile treaty obligations, eliminating child marriage with treaty obligations, protecting cultural integrity of indigenous peoples? This is addressed to Fergus. I'm not really sure, Fergus, if
yeah, I can have a go.
Yeah, okay, thanks so much.
Yeah, these are complicated questions. They're not one sentence answers to them, right? So part of the jurisprudence that is not well developed yet is, where is the line between the obligations of the state and autonomous self-determining decisions taken by indigenous peoples? We're getting a clearer answer of where the line is that keeps the state out of indigenous people's business, where the indigenous justice system operates and how the state has to recognize that. But where there are allegations of rights violations internal to indigenous peoples, there are complicated questions there, because individuals still have rights under those international treaties, irrespective of whether they're indigenous or not, and can bring complaints that the state of wherever they live has failed to guarantee their rights because their indigenous government has done X or Y, right? There's a case in the Inter-American system at the moment from Oaxaca in Mexico, where the indigenous municipal government refuses to let women vote. and the complaint was brought against the Mexican government for not intervening in this and forcing them to allow women to vote. The Inter-American Commission on Human Rights doesn't know what to do with this case, because it runs into two fundamental problems for them. One is they're fully on board with women voting, of course, but they're also fully on board with indigenous peoples making their own internal decisions. The UN Declaration on the Rights of Indigenous Peoples gives some guidance on this. If you look at, I think it's Article 34, maybe 33, basically says indigenous peoples have a right to maintain their own legal systems where they do not violate fundamental human rights. So there is an argument there that even if there's a decision for cultural reasons or autonomy, self-government reasons being taken, the operation of that indigenous legal system is not immune to the international human rights standards. Now, I would suggest that there's a middle ground in there somewhere, which requires thinking about how those rights are affected by that collective rights framework. This is especially relevant in the CEDAW context, right? The CEDAW general recommendation says that indigenous women have both individual and collective rights, yet the collective rights cannot override the individual rights. To me, that's the wrong approach. The right approach is, how do those two fit together? And does one condition another so that they can coexist? Obviously, you're not allowed to torture people. So if the indigenous legal system says torture that person, no, you can't do that, right? There are some things that you're not allowed to do whether you slap the cultural label on it or not. Eating people used to be a cultural tradition for some. Most people don't do that anymore, right? So there are things that may need to change, and they're not immune to sticking culture on them, right? I would say marrying children probably fits into that category, but the larger question there again is, how do the individual and collective rights frameworks interact? How should they interact? And it shouldn't always be one supersedes the other, right? And we now need to get into the details of what that means, right? I'm sorry, I don't have a better answer to the question than that. That's the best answer I have.
No, thank you so much, Fergus. And I read it because it's a very interesting and very difficult question to resolve the complexity between the exercise of different rights. Thank you so much for that. We have another question. I'm going to read it. Las alertas rápidas se presentan
Early warnings and urgent action, can they be submitted even though the internal legal resources in the country have not been exhausted? Karine, Fergus, Vincent,
Karine, I think that one is for you.
Thank you. ¿Sí me oyen?
Can you hear me? In general, I think that for CERD is not a requirement, having exhausted all the national resources, and it's not the case for CED or for forced disappearance. However, there should have been like information to the internal authorities, but it is not a requirement to exhaust the national resources, although this is something that quite sincerely is not part of the guidelines and the before and the after. But I think it is important for the committee to know whether or not the case is before the internal courts or whether it has been submitted before any regional, international court or any other mechanism. But in order to provide a more specific answer, to say no, it is not necessary to have exhausted all of the mechanisms national. I don't know whether Vincent has to add anything. No, I fully agree. This is exactly how I take it too. Thank you very much for these two answers. I would ask all of the participants to be understanding, and apologies because we couldn't read all of the comments, we couldn't answer all questions. I know the panelists have provided answers to many of your questions in the chat function, and I don't know whether you can stay over for a few minutes responding questions. Unfortunately, we will have to close the session, the training session, since we have to release our interpreters, whom we thank very much for their professional work this afternoon. I'd like to close the session by thanking the panelists, obviously, and all of the organizations, the IPRI, the Cultural Survival, because they really supported. And as I said, on March 31st, 3 p.m. CET, European CET, there will be a new session concerning training for indigenous issues. We're going to indicate this information regarding all of the sessions coming along, sessions programmed. We have at least 10 coming along, and this is the first one, and we will be sharing the information about the events. Likewise, I'd like to insist on the fact that videos with sessions in all languages will be available, and you can have access to them on our website. And Also, we will include the papers submitted by the speakers and the panelists. Thank you ever so much. I don't know whether the panelists would like to have a final word before we close the session. Nope, not the case. Well, thank you very much. Once again, thank you, all of you. Thank to everyone who participated today. And we would invite you to come and join us in the next session and have a great weekend. Thank you very much.